Did you know that the landmark case of Rupa Ashok Hurra v. Ashok Hurra set a significant precedent in Indian law regarding divorce and the rights of women? It's a case that reshaped how legal systems view personal relationships. In this video, we delve into the significant legal precedent of Rupa Ashok Hurra v. Ashok Hurra and Anr, a landmark judgment that has shaped the landscape of family law in India. This leading case provides valuable legal insights into the principles of dispute resolution and judicial decisions in civil law matters. We'll analyze the Supreme Court's verdict and its implications on divorce cases, highlighting the key takeaways for legal professionals and individuals seeking to understand the nuances of Indian law. By examining this case study, we'll gain a deeper understanding of the court's approach to interpreting legal principles and its impact on high court decisions. Tune in for a comprehensive commentary on this pivotal judgment and its ongoing relevance in the realm of family law and dispute resolution. Hi, I am Advocate Dr. Saurabh Kapoor, bringing you a video on this fascinating topic like this. But before you start watching this video, I request you to kindly like, subscribe and hit the bell icon to my YouTube channel to view videos like this more. Please leave a comment below telling your thought and idea about this video and future videos you want. Kindly share this video with your friends, family and social groups to spread this knowledge. The birth of curative petition. Indian jurisprudence has ever since seen some landmark developments either through the legislature or the judiciary. One can go on and on about the growth and immense development that our legal system has witnessed over these years, and it would never suffice. One such case that seemingly changed how our judicial system works and reaffirmed the fact that the Indian judiciary can go to any extent to meet the ends of justice is the landmark judgment of Rupa Ashok Hurra versus Ashok Hurra and Anr. A case specifically known for matrimonial discord when the question of the validity of a decree of divorce reached the Honorable Supreme Court of India and the woman withdrew her consent that she agreed while giving into divorce through mutual consent. In this matter, the following question of law arose: whether an aggrieved person is entitled to any relief against a final judgment or order of the Supreme Court after dismissal of review petition, either under Article 32 or otherwise. A bench comprising of Chief Justice of India, Justice S.P. Bharucha, and his companion justices, Justice S.M. Kadri, Justice U.C. Banerjee, Justice S.N. Variava and Justice S.V. Patil delivered a landmark judgment that opened a new dimension in the justice delivery system of this country. The court opined that since the case invokes the jurisdiction of the apex court under Article 32, it would be important to discuss the provision. Held, Article 32 invokes the writ jurisdiction in the nature of habeas corpus, quo warranto, mandamus, prohibition, and certiorari. With regard to writ jurisdiction, the high courts in India are placed virtually in the same position as the Court of King's Bench in England. It is a well-settled principle that technicalities associated with prerogative writs in English law have no role to play under our constitutional scheme. It is, however, important to note that a writ of certiorari to call for records and examine the same for passing an appropriate order is issued by a superior court to an inferior court which certifies the record for examination. On carefully examining the historical background and the nature of writ jurisdiction, which is of a superior nature over inferior courts and tribunals, the court opined that a writ of certiorari cannot be issued to coordinate courts and a fortiori to superior courts. Though the jurisdiction and orders of a high court are liable to be corrected by the Supreme Court in its appellate jurisdiction under Articles 132, 133 and 134 as well as under Article 136 of the Constitution, the high courts are not constituted as inferior courts in our constitutional scheme. Therefore, the apex court would not issue a writ under Article 32 to a high court. Further, neither a smaller bench of the Supreme Court nor a larger one can issue a writ under Article 32 to any other bench of the Supreme Court. It may further be noted that the superior courts of justice do not fall within the ambit of state or other authorities under Article 12 of the Constitution. Dr. Rajiv Dhawan, learned senior counsel, argued that since the Supreme Court is a creation of the Constitution, so the corrective power has to be derived from the provisions conferring jurisdiction on the Supreme Court like Articles 32 and 129 to 140. Such a power doesn't arise from an abstract inherent jurisdiction. Mr. Ranjit Kumar, learned senior counsel, advocated that in case of any manifest illegality and palpable injustice, the Supreme Court under its inherent powers could reconsider final judgment or order passed by the Honorable Court. It was submitted that the composition of the bench might include senior-most judges along with judges who pass the order, if available. He also submitted that while considering such curative petitions on the ground of manifest illegality and palpable injustice, in the rarest of rare cases, factors like the doctrine of stare decisis and the finality and certainty of the law declared by the apex court are required to be kept in mind. The concern of the apex court for rendering justice in a cause is no less important than the principle of finality of its judgment. The apex court, to prevent abuse of its process and to cure a gross miscarriage of justice, may reconsider its judgment in exercise of its inherent powers. The next step is to specify the requirements to entertain such a curative petition under the inherent powers of the Supreme Court so that floodgates are not opened for filing a second review as a matter of course in the guise of a curative petition under the inherent powers. It is a common ground that except when very strong reasons exist, the court should not entertain an application seeking reconsideration of an order of the apex court which has become final on dismissal of review petition. However, a petitioner is entitled to relief ex debito justitia if he establishes violation of principles of natural justice and where in the proceedings a learned judge fails to disclose his connection with the subject matter or the parties giving scope for an apprehension of bias in the judgment adversely affects the petitioner. The petitioner in the curative petition shall aver specifically that the grounds mentioned therein had been taken in the review petition and that it was dismissed by circulation. The curative petition shall contain a certificate by a senior advocate with respect to the fulfillment of the above necessary requirement. The curative petition, keeping in mind that there lies no appeal against an order of the apex court considering that there is no intra-court appeal, and the well-settled principle that an act of the court shall prejudice no one, the concept of curative petition came into existence considering that it would be an extremely strong discretionary power and could be exercised only in rare cases. Before delving into the crux of the curative petition, it is important to state in brief the procedure involved. The Supreme Court shall have inherent and plenary jurisdiction to hear such petitions. Order 48 of the Supreme Court Rules, 1966 states that after the dismissal of a case in review under Article 137 of the Constitution, by way of circulation, a curative petition can be filed under the inherent jurisdiction of the apex court to prevent abuse of its process and cure gross miscarriage of justice, as per the law laid down in the Ashok Hurra case. It can either be civil or criminal petition. Such a petition shall be circulated to and heard by a bench of 3 senior-most judges as well as the judges who pass the judgment in question. Unless otherwise ordered by the court, such a petition shall be disposed of by circulation without any oral arguments. But if the bench before which such a petition is circulated deems just and proper, it may list the same for hearing before the same bench, as far as possible. The affidavit which may accompany the curative petition shall clearly mention that the petition is governed by the judgment in the Ashok Hurra case. It shall contain specifically that no new grounds have been taken and the grounds mentioned in the petition had been taken in the application for review, which was dismissed by circulation. It shall accompany with a certificate of a senior advocate that the petition meets the requirements delineated in the case mentioned, a certified or authenticated copy of the judgment or order complained of, and a certificate of the advocate on record to the effect that it is the first curative petition in the impugned matter. It is specifically mentioned in the handbook that the curative petition shall not be governed by the provisions of the Limitation Act, 1963. As far as the fee is concerned, it is stated that the same fee as was paid in the original proceedings shall be levied. Importance of this judgment. This judgment is a benchmark in the field of judicial scrutiny. This case reaffirmed that the judiciary in this country and especially the highest judicial body, the Honorable Supreme Court, will leave no stone unturned to impart justice to people. The court will go to any extent to satisfy the litigants that justice has been done even if it means to review its own decision a second time. However, this is a matter of absolute discretion of the court. On 20th of February, 2020 a 3-judge bench of the Apex Court comprising of Chief Justice S. Abab, Justice N.V. Ramana and Justice Arun Mishra dismissed the curative petition filed by the Association for Victims of Upar Tragedy, an association of victims of the 1997 Upar Cinema Fire tragedy case, sparing the Ansal brothers further jail term. The rules around curative petition are fairly tight as the petitioner has to establish that there was a genuine violation of the principles of natural justice. The Supreme Court on 19th of March, 2020 rejected the curative petition filed by Pawan Gupta, one of the 4 death row convicts in the 2012 Nirbhaya gang rape and murder case, against the dismissal of his juvenility claim. A 6-judge bench headed by Justice N.V. Ramana dismissed the plea, saying no case is made out. The application for oral hearing is rejected. We have gone through the curative petition and the relevant documents. In our opinion, no case is made out. Hence, the curative petition is dismissed, said the bench also comprising of Justice Arun Mishra, Justice R. F. Nariman, Justice R. Bhanumati, Justice Ashok Bhushan and Justice A. S. Bopanna. Thus it can be concluded that though curative petition is a much-needed judicial relief after all reliefs are exhausted, it is purely based on judicial discretion without any specific postulates to entertain such a petition. However, it cannot be ruled out that the judgment in Ashok Hurra case was indeed a benchmark for justice delivery system in India. 1. AIR 2002 SC 177. 2. 32. Remedies for enforcement of rights conferred by this part. The right to move the Supreme Court by appropriate proceedings for the enforcement of the rights conferred by this part is guaranteed. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate, for the enforcement of any of the rights conferred by this part, without prejudice to the powers conferred on the Supreme Court by clauses, and Parliament may by law empower any other court to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause. The right guaranteed by this article shall not be suspended except as otherwise provided for by this Constitution. 3. 132. Appellate jurisdiction of Supreme Court in appeals from high courts in certain cases. An appeal shall lie to the Supreme Court from any judgment, decree or final order of a high court in the territory of India, whether in a civil, criminal or other proceeding, that the case involves a substantial question of law as to the interpretation of this Constitution. Where such a certificate is given, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided. Explanation: for the purposes of this article, the expression final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. 4. 133. Appellate jurisdiction of Supreme Court in appeals from high courts in regard to civil matters. That the case involves a substantial question of law of general importance, and that in the opinion of the High Court the said question needs to be decided by the Supreme Court. Notwithstanding anything in Article 132, any party appealing to the Supreme Court under clause may urge as one of the grounds in such appeal that a substantial question of law as to the interpretation of this Constitution has been wrongly decided. Notwithstanding anything in this article, no appeal shall, unless Parliament by law otherwise provides, lie to the Supreme Court from the judgment, decree or final order of one judge of a high court. 5. 134. Appellate jurisdiction of Supreme Court in regard to criminal matters. An appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a high court in the territory of India if the High Court has on appeal reversed an order of acquittal of an accused person and sentenced him to death, or has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death, or that the case is a fit one for appeal to the Supreme Court, provided that an appeal under subclause shall lie subject to such provisions as may be made in that behalf under clause of Article 145 and to such conditions as the High Court may establish or require. Parliament may by law confer on the Supreme Court any further powers to entertain and hear appeals from any judgment, final order or sentence in a criminal proceeding of a high court in the territory of India subject to such conditions and limitations as may be specified in such law. 6. 136. Special leave to appeal by the Supreme Court. Notwithstanding anything in this chapter, the Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence or order in any cause or matter passed or made by any court or tribunal in the territory of India. Nothing in clause shall apply to any judgment, determination, sentence or order passed or made by any court or tribunal constituted by or under any law relating to the armed forces. 7. 12. Definition. In this part, unless the context otherwise requires, the state includes the Government and Parliament of India and the Government and the legislature of each of the states and all local or other authorities within the territory of India or under the control of the Government of India. 8. 137. Review of judgments or orders by the Supreme Court, subject to the provisions of any law made by Parliament or any rules made under Article 145. The Supreme Court shall have power to review any judgment pronounced or order made by it. Chief Justice S.P. Bharucha, Justice Syed Shah Mohammed Quadri, Justice Umesh C. Banerjee, Justice S.N. Varya V.A. and Justice Shivaraj V. Patil. The doctrine of ex debito justitia. The doctrine of ex debito justitia, which translates to by debt of justice, is a fundamental principle that guides the Supreme Court's approach to reconsideration of its judgments. This doctrine recognizes the court's inherent power to correct errors and prevent miscarriages of justice, even in the absence of specific statutory provisions. The rationale behind this doctrine is the belief that the administration of justice should take precedence over procedural technicalities. Limitations on challenging Supreme Court judgments. While the Supreme Court possesses the power to reconsider its judgments, there are certain limitations on the mechanisms through which such reconsideration can be sought. The court has consistently held that a judgment or order passed by it cannot be challenged through a petition under Article 32 of the Constitution, which deals with the enforcement of fundamental rights. This principle has been reiterated in several cases, including Naresh Sridharmarikar and Ors v. State of Maharashtra and Anr, A.R. and Tully v. R.S. Nayak and Anr, S.M.T. Tribunibin v. State of Gujarat, and Ajit Kumar Bharat v. Secretary Indian Tea Association and Ors. 4. The curative petition, a rare remedy. To address the need for reconsideration in exceptional cases, the Supreme Court has established the mechanism of a curative petition. This petition can be filed after the dismissal of a review petition, provided that specific grounds are met. The petitioner must demonstrate that there has been a violation of the principles of natural justice or that the judge presiding over the case was biased. The curative petition process is stringent and involves several safeguards. The petition must be certified by a senior advocate, and it is initially circulated to a bench of the 3 senior-most judges and the judges who passed the original judgment. If a majority of the judges on the bench conclude that the matter requires a hearing, it is listed before the same bench. The bench may also appoint a senior counsel as amicus curiae and impose costs on the petitioner if the petition is found to be without merit or vexatious. The principle of finality and precedent. While the Supreme Court acknowledges its power to reconsider judgments, it also recognizes the importance of finality and precedent in the legal system. The court has emphasized that the power to overrule previous decisions should be exercised sparingly to avoid confusion and instability in the law. The court must be satisfied that the previous decision was clearly erroneous before overruling it, as the finality and precedent set by the Supreme Court should not be easily challenged. Today, we're going to explore one of the most influential judgments in Indian family law, Rupa Ashok Hurra v. Ashok Hurra and Anr. This landmark decision has had a lasting impact on the country's legal landscape, particularly when it comes to divorce and the rights of women. The case is significant not just because of its verdict, but also because of the complexities it unravels. It's a story of love, relationships, and the intricacies of the legal system. Rupa Ashok Hurra v. Ashok Hurra and Anr is a case that laid the groundwork for many future judgments in Indian family law, and its relevance continues to be felt even today. The main issues at stake in the case of Rupa Ashok Hurra v. Ashok Hurra and Anr are quite complex. Essentially, it's a story of a marriage that didn't work out, and the legal battles that ensued. At its core, the case revolves around the complexities of divorce, the rights of women, and the implications of the court's decision. It's a case that challenges our understanding of personal relationships and the role of the legal system in regulating them. The rights of women are a critical aspect of this case. The judgment raises important questions about the agency and autonomy of women in marriages, and how the legal system should respond to their needs. The case also highlights the need for a more nuanced understanding of divorce and its implications. It's not just about the legal formalities, it's about the human emotions involved, the social stigma attached, and the long-term consequences of such a decision. In Rupa Ashok Hurra v. Ashok Hurra and Anr, the court had to grapple with some tough questions. What constitutes a valid marriage? What are the grounds for divorce? And how should the court balance the rights of the parties involved? The legal arguments presented in the case were extensive, with both parties presenting competing narratives about the state of their marriage. The court had to sift through the evidence, evaluating the credibility of the parties and the authenticity of their claims. The social context surrounding the case is also crucial. It was a time when divorce was still stigmatized, and women were often expected to prioritize their families over their own well-being. Against this backdrop, the court's decision assumed even greater significance. The facts of the case are quite intriguing. Rupa Ashok Hurra, the petitioner, sought to challenge the divorce decree granted by the family court. She argued that the divorce was invalid, and that her husband had concealed certain facts from the court. Ashok Hurra, the respondent, countered that the divorce was valid, and that Rupa was aware of the circumstances leading up to the divorce. The case was complex, with both parties presenting competing versions of events. The legal arguments presented in the case were based on various provisions of the Hindu Marriage Act, 1955. The court had to interpret these provisions in light of the facts presented, and arrive at a decision that was just and fair. The background of the case is critical to understanding the legal arguments presented. It's a story of love, relationships, and the breakdown of a marriage. In Rupa Ashok Hurra v. Ashok Hurra and Anr, the Supreme Court had to navigate a complex web of emotions, relationships, and legal technicalities. The bench comprising Justice R.C. Lahoti and Justice B.N. Agarwal delivered a landmark verdict that would go on to shape the course of Indian family law. The Supreme Court's ruling in the case of Rupa Ashok Hurra v. Ashok Hurra and Anr is worth analyzing in some detail. The court's decision was based on a careful evaluation of the facts presented, as well as a nuanced understanding of the legal provisions involved. The court's reasoning is fascinating because it highlights the need for a more contextual understanding of personal relationships. The judges recognize that relationships are complex, and that the legal system must adapt to these complexities. The immediate impact of the court's decision was significant. For Rupa Ashok Hurra, it meant that her divorce decree was set aside, and that she had the opportunity to rebuild her life. For Ashok Hurra, it meant that he had to re-examine his role in the marriage and the events leading up to the divorce. In many ways, the case of Rupa Ashok Hurra v. Ashok Hurra and Anr is a testament to the power of the legal system. It shows how the judiciary can shape the course of individual lives, and how it can respond to the needs of vulnerable individuals. Conclusion. As much as one wants to believe, judges aren't gods. They are human beings, and humans are bound to err. While decisions of lower courts can be reviewed, appealed against, or revised under various provisions of the Indian Constitution, the Supreme Court could not go against its own judgment to make changes. However, considering the fact that errors can be made by a human being, it was important to introduce a concept wherein the Supreme Court can review an order passed by them. This is nothing but just an additional step to meet the ends of justice in totality. The Supreme Court's approach to reconsidering its judgments reflects a delicate balance between upholding the principles of justice and maintaining the integrity of the judicial system. While the court possesses the inherent power to correct errors and prevent miscarriages of justice, it exercises this power with utmost caution and circumspection. The curative petition mechanism, coupled with the court's adherence to the principles of finality and precedent, ensures that the pursuit of justice is tempered by the need for consistency and certainty in the law. The key takeaways from this case are many. Firstly, it highlights the need for a more nuanced understanding of personal relationships. Secondly, it emphasizes the importance of context in legal decision-making. And finally, it shows how the legal system can adapt to the changing needs of society. In the broader context of family law in India, Rupa Ashok Hurra v. Ashok Hurra and Anr is a landmark case that has had a lasting impact. It has influenced the development of jurisprudence on divorce, and has shaped the way courts approach cases involving personal relationships. The evolving nature of legal interpretations in divorce cases is also worth noting. The case of Rupa Ashok Hurra v. Ashok Hurra and Anr marks a significant shift towards a more nuanced understanding of personal relationships, one that recognizes the agency and autonomy of individuals. Thanks for watching. If you have any thoughts on the case, please share them in the comments below. And if you're interested in learning more about family law in India, be sure to check out our next video on the topic.